this platform and share with you some important issues and opinions, of course, because everything is opinion. I want to start from the previous speaker comment, and I want to comment that, of course, technology is a must for transformation, but without ethos, without inclusiveness, without empathy and peace, of course, it's impossible and forgiveness, it's impossible to transform the world. It's my pleasure to present you today the issue of AI-based patenting in general, and offer you some ideas, but in a more detailed way, because the previous speeches gave the general ideas, but also, apart from being editor-in-chief in several journals, I am in the Science of Law journal, co-editor-in-chief, and I have to be a bit more specific about these issues of patenting. So I will try to convey to you details about patenting and AI. The talk, I will try to be on time as much as possible, but not to exceed, let's say, 25 minutes, 30 minutes maximum. So my time is very strict and the material is too much, but I will succeed, I think. So the general agenda and idea is two things. First, to discuss about details of patenting, but in brief. And second, the major part is AI-aided patenting. Here, I will not describe the tools, but I will try to answer some basic questions. And the first question that was raised in the previous talks was, when we use AI, who is patenting what? Is AI an inventor? Who is the inventor? The company? OpenAI, Facebook, company, Meta, etc., company building the LLMs. Who is the inventor? Maybe the algorithms? Look, this answer is very simple. When we produce new products and we want to patent a technology, the technology uses tools. We know all that in manufacturing, we use machines for building, for designing buildings and implementing buildings. We need special tools for constructions. Who is the patenter there? Is the tool? Of course, no. No one can believe that, for instance, a machine in manufacturing or a chemical substance that is used, it's known, which is a tool, of course, used in the patent, in the new innovation, that this is the innovator. Of course not. The tools are never the innovators. And AI is a tool. Believe me, it's only a tool. So we need some details here because the real questions are not these. The algorithms are not innovators. Don't believe such things. The problem is, however, how to discriminate the algorithms and the performance, let's say, of the intelligent systems and human contribution. The difficult thing is to distinguish and discriminate these issues. I will come to this with certain cases. As I told you, this is closely related to laws. and the legal system. As working, apart from being an engineer and a professor in artificial intelligence, I'm working also with the laws about regulations and the legal system. So this is the absolute context, but I will work fast with you about the details needed in order to understand where AI can be involved in the filing process. So we have seen what is a patent. We will see more exactly what is patentable and what is non-patentable, and we'll try to connect this with AI. About minimal things about drafting, because I will not be involved today with drafting. And also, as the context is that our patenting efforts should focus on PCT, Paris Treatment, and Budapest Treaty. These treaties are important because we have to understand that what we want to patent should be international patenting, not only in US, in India, in China, or whatever. So Budapest Treaty is about internationalization of patenting. So nearly all patent offices follow the same rules based on Budapest Treaty and PCT Paris Treaty, which is for biochemical substance, but I will not be involved at all. So by patenting, as we have already told previously, is the effort to introduce and establish a monopoly in the consideration of the invention. So you have an invention and you want this invention to be your monopoly in any product. So we have the invention, the application, the satisfaction of all Budapest Treaty conditions and special conditions per country, of course, and patentability. So the important thing is to prepare the file system. This is the most important thing in order to patent. So the overview of what is going on in patentability is not only to have an invention, but to support fully your invention. So you should support over several entities. And the first entity is the patent office with the general controller, the controllers, associate controllers, and the examiners. It's a hierarchical structure, as you can see in this transparency. And of course, the most important thing that you should support, and I will connect this also with AI, it is about the invention. So what is the real thing here in supporting a patent is to claim that you have an invention, you have something brand new as a product or a process. This is the most important thing, effective from 2003, effective from the Budapest Treaty. So what is patentable actually, and what is invention, first of all? It might be fundamental research, but not algorithms. I will explain these things, but in very brief, as you understand. You should have an improvement of an existing art, of an existing technology, of an existing product, of an existing process. By art, we mean everything here as a process, product, technology, etc. You should solve unsolved problems, unaddressed issues. It should be something as a new solution, as a different approach. Otherwise, we are not talking about invention. So, what is invention? We explained somehow. Is the invention patentable? What is non-patentable? Is the invention novel, inventive? What is the prior art? What is the prior disclosure? Prior art means what is the state of the art in this subject, and what is prior disclosure? Have you revealed in some way the invention by talking to others, by publication, etc., etc.? Is oral disclosure? You talk to others, it's not allowed. You have a printed publication, it's not allowed. You have announced in a blog, it's not allowed. Otherwise, you don't have a patent. So you should have to conduct a search for prior art. Here AI can help. I'm trying to connect with AI in every transparency. So you should conduct a research on the previous art. AI can help here a lot. You should enlist all open problems of the prior art in order to see if your idea is a real invention. What is the problem? It should be very specific, not generalities here. It's very specific and formulated good in an analytical formulation problem or algorithm, and you try to solve by this invention. What is the novelty? We should be very specific. This is also for the academic papers. Is the solution obvious? If it's an application only of new technologies, is not novelty. Is it artificially excluded? Is there any publication ensued with this? So you should ascertain all things, and you should ascertain also what you need. Do you need provisional or the full filing? Provisional patent or full patent? And of course, no question, Paris and the Budapest Treaty framework in order to apply. What is not patentable? Anything that is frivolous and trivial. Anything that is in contrary to well-established natural laws. I see many in LinkedIn saying that Einstein was wrong with the theory of relativity, etc. When we have 100 years of evidence that everything like this is true, and therefore theory of relativity is not just a theory, is fact, is a set of facts. So we can talk about natural laws as Newton's laws. Anything that you claim that is against these laws cannot be patented. No one will sign. Contrary to morality and ethos, contrary to public health, contrary to environment. Look, you cannot patent a nuclear bomb, all right, to be honest. You cannot patent scientific principles and abstract theories. Mathematics cannot be patented. You can gain a prize, the Field Prize, but you cannot gain a patent with mathematics. Is a new property or use of a known substance? No, this cannot be patented. A new property that is discovered of an old substance cannot be patented. But a product coming from a new use, a new process coming from a known substance, but discovering another mechanism, let's say, coming from the new substance, this could be patented. No mixtures. Mere mixtures, hybridizations are not patented. If it's simple hybridization, no. We need something innovative there, an innovative way to integrate things. The same is for the papers. Also treatments of health treatments including diagnostic methods, but new machinery for diagnosis, of course, can be patented. and so on. Essential biological processes. You cannot patent that you discover, let's say, a new hormone. Why to patent this? So you understand what is the kind that cannot be patented, and you have a feeling of what can be patented. But the major issue that you should care also is about the publications, the general knowledge, the common general knowledge, which is published or not published. This cannot be, of course, patented. Publications are risky. You should never reveal, you should never disclose your information before patenting your invention. So even a single disclosure is sufficient to be out of the patent office. You understand that the actors are many in patenting, patent office, as we described, the licensee assignees in the patent office, the examiners, the CERTs. I will come to this because I will talk about AI in 2-3 minutes. Technical peers and skilled persons that can check your patent, your competitors, companies or whatever else, the commercial players, the general public, they are all actors in examining your patent. So even if something, even you have a patent from the patent office granted, okay, you have something, but you are not sure because your competitors the provisional and the complete type of patenting. So we should be very careful with what we want. The provisional is simple. The provisional is, as I will show you, because I don't have a lot of time, the provisional patent means you don't have all claims. This is the basic thing. You have, of course, descriptions, you have to convince about invention, but you don't have claims. So you have specification, all specifications. You should explain everything in the description, even in the provisional patent. There should not be any ambiguity in your description. You should fully explain the problem, you should fully explain the solution, the invention, everything, in the provisional and in the full. So these are the things that you should provide to the patent office. Title, field of invention, background, prior art details, objects and objectives, statement, detailed description of invention, for both provisional and complete. AI, where AI can help, actually in everything. In all your statements, you can use AI, but you should be, of course, very careful, as I will explain. Again, you should take care in order to claim, initially at least, all major aspects and not all details, but initially, even in the provisional patent, in provisional filing, you should have some wording for your claims, not full explanations, because the claims is another story. So about product, process, apparatus, whatever, you need to discuss it fully in your utility filing. Okay, I will skip some things to come to most crucial and AI now. So the invention, in order to better understand, I have built this diagram. You can see that the prior art is like things like planets, and the real sun is you, different. There should be differences, a lot of differences, substantial differences of unsolved problems not in the prior art and well described. So I will skip about invention because we have discussed a lot today. And I want to come to the claims before going to AI. The claims is the details, legal details about your invention. Where you want the monopoly. This is the problem. Where, because patenting means you want monopoly. Where you want monopoly? Actually, you want to all applications. Because whatever, be careful, whatever you are not claiming is not patented. So you should claim everything in order, all possible applications, because otherwise another competitor will do the job for you for this thing that you have not claimed. So this is your checklist. All your research, the invention is patentable, what you want to patent, all your claims, all the prior art, what is non-patentable in your system, you should exclude, and you should try to build the monopoly everywhere that is possible. So let's go now, after this discussion about patenting, provisional and full patenting, after having the idea that you should be very, very careful to include your monopoly everywhere with your claims will come, of course, in the full patenting, in the complete filing, which is for not, let's say, mandatory in the beginning. Mandatory is the provisional. After 1 year, after you get the provisional patent, then you proceed with the claims, with the complete patent. Needs more years. 1 year is the timeline for a provisional patent, but you need more, maybe another year more, in order to establish the full patent. So AI now. AI can be used in research, and we use it every day, we have to admit. We have several cases. I have identified and I have isolated some cases in order to understand the issue of AI in patenting. Thaler and Vidal, of course, they are companies. And what you will see is from the Karras from USA. Because in USA there is large innovation and they have a lot of problems with patenting there. There is nowhere else such war between commercial players than in USA. So I decided to bring into your attention some cases from USA having to do with AI in order, and some examples, in order to understand how AI should be treated. So through certain cases like Thaler and Vidal, in 2022, we started the conflicts and how to use the conflicts on how to use AI. So the issue is big. AI is a player in the patenting process. Many things in the patent come from AI, generative AI. So is this patentable? This is the question. In order to, let's say, to guide such AI-assisted invention, I have summed up here the things. And the major things come from the so-called Panu factors. Panu, of course, is an Indian name because it reflects two Indian brothers. I suppose they are brothers because they have the same name. They had a company, a lens company. They had an innovation there. It's a case against, as you see, these guidelines come from 2024, 1 year ago, and the Panu case came in 2023, in the Kurtz and 2024, the decisions. So we will delve now into the Panu factors. It was a trial against another player, commercial player, in USA, of course. This lens company, another against another lens company. So the decisions there about AI-assisted inventions, they are not categorically unpatentable for improper inventorship. This means something very clear from USA Kurtz, I repeat. And of course, it's very reasonable. It says that using AI doesn't mean you don't have a patentable filing. This means that even if your percentage of using AI is 90, let's say, percent, it's not like the academic writing, where we want all, as editor-in-chiefs, we want less than 20%. It's not like this. You can use AI. It's not unpatentable if you use AI. But what is the issue here? Is the Panu factors. I will give an example in 5 minutes because I have also to respect the time. So AI can be used, first of all, but it should meet Panu factors. This is the critical thing. Failure to meet Panu factors precludes the person from being named an inventor. So be careful. Everyone uses AI should respect these Panu factors. Of course, Panu factors, we call it the Kurt, from the Kurt decision, of course, you understand. So what are the Panu factors and the guiding principles? GP is the guiding principles. The first Panu factor is conception. Who conceived the invention? It's a major issue. AI or a person? Who conceived and what is the contribution of AI? Yes, you can use AI, but what is human, the natural person contribution in the invention, in the conception, first of all? Who was the idea? If you use AI, you should present exactly what AI did and what you did. Also, this is in your papers. Okay, you can camouflage, let's say, AI, GPT, Grok, or whatever in your paper. You can do this easily, paraphrasing and so on. But the idea, the real idea, from where it comes. And be careful, because we are talking about money here. Patenting means money. It's not like academic papers. The reviewers, the referees, may not see your AI cheating, let's say, in your paper. But here, they should try to find, the examiners, every evidence about human contribution. This is the major issue, human contribution. AI can contribute, but where it contributes is the big issue to discriminate, as I told you from the beginning, AI and human contribution. So conception analysis should be made by the examiners and, of course, by your commercial competitors. This was happening in the Panu case. The second factor, quality of contributions. Is it a trivial contribution, the human, and AI made the job? You understand? Third factor, mere explanation of the state of the art is not a contribution. You understand also well. So, the application of Panu factors to determine whether the natural person has been really involved in an AI-assisted invention is done claim by claim, fact by fact, case by case, very thoroughly, not as referring an academic paper. Here we're talking about, again, money. When a single person uses an AI system to create an invention, the single person should have significant contribution. This is the second factor, quality of contributions. No requirement for the natural person, natural inventor, to contribute to every claim with significant, let's say. But each claim should have at least one natural person, natural inventor. And each inventor of every claim, because there might be different, to have a very clear, now you understand also, it's not like the old way, we put 5 names, we all made the patent. Bullshit. Now, they examine everything. What is human contribution and by whom? Like in the papers. Now, you should claim what you have done. All journals, all Scopus journals require authorship, real authorship. The same with patents. So the guiding principles coming from Panu factors is the natural person use of an AI system should, in an invention, does not negate the patent, but only if there is significant contribution in every claim, in every part of the invention of natural persons. Merely recognizing a problem or, let's say, prompting is not conception. Conception is something more important. Reducing an invention to practice alone is not significant contribution for inventorship. A natural person, but who develops an essential building block, new things, new processes, could claim. Maintaining intellectual GP5, maintaining intellectual domination over AI system, this means that the inventor should be, of course, natural person, with substantial contribution, even using AI systems, AI assistance. So, because my time is over, I will give you an example. This example is given by the US Patent Office. The example is this, a mechanical example with a scenario. The scenario is that, for instance, two engineers make a system by prompting an AI system, GPTs. It's about a transaction system. So they have used the prompt, create an original design for a transaction for a model car, it's for a car, including a schematic and description of the transaction. You can prompt, of course. Look here, the analysis of the examiners. The engineers recognized the problem, needing a transaction. GP2, guideline principle 2. The recognition of a problem is not innovation, is not conception. So PANU factor 2 is violated. Prompted the AI system to solve the problem. Yes, they prompted. Give me schematics, give me everything. Prompt is only a restatement, no inventive contribution of how the prompt is constructed. There is no innovation here. Reviewing the AI output, GP3, guideline principle 3. Recognition and appreciation, therefore supervision of the system that this is correct or not correct, without a contribution is not sufficient. So being simply a supervisor of an AI system is not patentable. Do you understand? It's not patentable. You should have a clear contribution, not supervision only. A different scenario. Morgan has used the schematic and he builds the transaction based on schematic. He follows exactly the schematic, not altering the design. He selects steel, a known material, in order to construct the car. So he selects a material. The analysis now. They recognize the problem. Okay, we have discussed already this. This is not. You cannot claim patent here. Reduce the transaction to practice. Reducing is not significant contribution. Selected steel, but steel is a known material. You do nothing. There is no any invention. So the AI system built and you made some things, small things. You selected other material from AI or whatever, but it's non-material. So you violate PANU factors. You cannot be granted a patent. Scenario 3, and I'm finishing. The engineers provide different schematics. They have the schematics of AI, but they alter completely. They are based on schematics, but they alter the design. They experiment with the alternate design and create a new different design. And also makes another process. One of the engineers, Morgan, makes another process. So in this case, they created the new design upon a suggestion AI from AI design. They elongated the case, the specific placement of the elements in cases, so they alter all arrangements. The casing also, everything is changed, and another approach, another process in clip fashion. So, GP1, a natural person use of AI is not a problem if there is contribution of the inventor. It's not violated. Original design by a natural person and a significant modification in fashioning. So overall, scenario 3 is successful for having the patent granted. With this, because my time, I think these are some of the resources I use, and with this, I finish this speech. I hope you have understood the legal issues and you have understood also the important things in how you should treat AI-assisted patent systems in order to make a real patent. I hope this have been helpful. It's some details that we should know from now on. Thank you very much for your attention. I'm here for your questions and whatever you like to ask.